So I'll introduce today's speakers and then we'll get started on today's session. Just before I do, I think we're going to have a little poll and ask you a little bit about what you know about third-party funding. So whilst I introduce the speakers, if you can vote on that and we'll find out if you know anything about the topic of today's session. So our first speaker this morning is James Drayton. He's the Chief Executive of Raven Group. Raven Group provides financial and dispute resolution services to international construction companies for the effective management of disputes arising on infrastructure and related projects. We also have from another funder, Andrew Roberts. He's an investment manager at Augusta Ventures. Andrew's a member of Augusta's due diligence team focusing on construction and infrastructure disputes. Prior to joining Augusta, Andrew spent many years as a private practice construction lawyer. And finally, we have Khushboo Shadhadpuri, who is Senior Associate at Tamimi and Company. Khushboo is a dual qualified lawyer admitted to practice in Singapore and the state of New York. Her practice focuses on international dispute resolution and she's based in the Middle East. So if you've all voted, should we take a look at the results of the poll? So most of you have got limited knowledge. So hopefully we're gonna expand that. I'm hoping today's speakers have extensive knowledge they can share with us today. And there are some of you with no knowledge at all, which is quite helpful for our first question. I'm going to come to you first, Andrew, because as we've seen, there's a mixture of attendees and some people kind of know nothing at all about litigation funding or dispute funding. So with that in mind, let's start at the beginning and maybe explain for those not so familiar what it is, how it's used and what your role in the process is.
Thanks very much, Annie. So to summarise quickly as possible, third-party funding is the provision of funding for the costs of pursuing legal claims. So that can be your barristers' fees, expert fees, tribunal costs, and any other costs associated with running an expensive legal claim. Funder provides that capital, and in return, if the claim is successful, funder gets a repayment and a success fee. So that's generally how it works. And as you can imagine, that means it's a very high-risk investment for us. It's non-recourse funding, so we only get our money back and any upside if the claim wins. And furthermore, we have no control over the proceedings. Once we've committed to funding the case, we essentially have to sit back and watch and see what happens. So that means we have a very rigorous diligence process, and we will only fund good claims and claims that are run by a good legal team. That's generally what my job is to assess legal claims and decide whether they're good for investment or not. In the construction context, which is where I do all of my work, funding is relatively new. We've been doing it full time for around 2.5 years. It's been funding generally has been around for a lot longer, but we think funding is an excellent option for construction claims. We'll fund all types of construction claims, from final account disputes to terminations, professional negligence claims, variations in EOT claims, in any forum really. So generally, our claimants are more often supply side because we tend to fund claimants rather than responding parties, simply because claimants are the ones who are going to stand to recover sums of money from which we can get our repayment. That's generally how things work, but we do fund on the other side of disputes as well. Yeah, generally it's seen as an attractive thing for contractors in particular. Funding is off balance sheet because it's non-recourse, and if you're getting funding to run your claims, then obviously it's not eroding your project margins and the like. So generally it's seen as quite attractive to commercial directors and CFOs. So it's early days for construction funding, but that's essentially what it is.
Andrew, that's quite a good overview of the topic for today. I must admit, it's not something I came across until a couple of years ago at all. Khushboo, does it matter where you are in the world? Are the rules different depending on what country you're in? How does it work elsewhere?
Thanks, Annie. I think until very recently, when one thought of third-party funding, there were only a handful of jurisdictions that will come to mind. So Australia, Canada, the United States, and the UK. in particular, these jurisdictions had very early on moved away from the prohibitions that they once had in place that prevented third-party funding, such as the doctrines of charity and maintenance. But in recent years, there's been a global consensus to accept third-party funding in both international arbitration, but also domestic litigation matters. And we do see these trends worldwide. In Asia, for example, Hong Kong since 2019 has allowed for third-party funding in its arbitration proceedings. Singapore since 2017 has allowed for third-party funding in international arbitration and related litigation proceedings, and the government's even contemplating allowing funding for even domestic arbitration and mediation matters. The Middle East is another region that we've seen inroads in third-party funding. It's a region that is predominantly made up of civil law jurisdictions, which generally don't have any express prohibitions against funding in the same way that common law jurisdictions do by their traditional doctrines of maintenance and charity. So similarly, though, they have no prohibitions against funding. So, they're silent either way. And the UAE does stand out in the Middle East because it contains pockets of financial free zones which operate as autonomous jurisdictions modeled on the common law. And these free zones have provided for third-party funding since 2017. In particular, the Dubai International Financial Center, as well as the Abu Dhabi Global Market Court. So, although every jurisdiction, I suppose, treats funders and funding a bit differently, the general consensus has been towards accepting and allowing for funding. Where there are common law jurisdictions, we've been seeing a trend towards expressly providing for rules for funding. Where the civil law jurisdictions, although they're more silent on it, we have seen some positive rulings by courts in these countries. The Swiss courts, for example, have recently, well, not recently, but in the last 10 years have ruled that they don't consider third-party funding and funding arrangements to be illegal. So it's a lot more comforting for funders where they see these sort of positive trends. But generally, there's definitely an uptick in the funding market and in the world generally.
Thanks, Khushboo. Andrew, coming back to you, you mentioned there that part of your role is to assess the cases. So how do funders assess risk when accepting cases? And with some of the cases that have been recently, are funders particularly risk averse or?
Yeah, I mean, funders are obviously risk averse, that's for sure. But as I said earlier, it's a high risk game, and we know that we're not going to win every case. So it's a question of making sure we're winning more than we're losing in the broadest sense. The types of case law issues that come up from jurisdiction to jurisdiction, that we generally are aware of those risks anyway, and they're generally provided for in the way that we approach our funding. The general trend is certainly for jurisdictions to be opening up to third-party funding, and that's certainly what we're seeing. Recent jurisdictions, India, Hong Kong, are really opening up. So across the globe, it's heading in that direction. In terms of assessing risk, probably the most significant thing that funders do that perhaps claimants and law firms even don't think about quite so much at the beginning of a dispute is the money at the end. And that's in terms of both how easily can that claim be enforced, a successful judgment or award, how easily can it be enforced, and then is the defendant going to be good for the money? Are we going to be able to get the money out of them? So that's something we focus heavily on at the start, and that generally is an added sort of benefit to the claimant, really, that we do that sort of extra diligence on that side of things. But generally speaking, with the case law, everything's heading in the right direction, generally speaking.
Okay. And James, what about specific risks for the construction industry?
Morning, everybody. Yes, there are specific, when you talk about specific risks, and this is in the context of risks that are outside the sorts of risks that are generally applicable to a financier considering applications for finance for their litigation. The construction industry does present a lot of issues. The first issue is can you enforce the claim itself, and that depends a great deal upon the jurisdiction that you're seeking to enforce your claim, to achieve your claim first of all, and to have it recognised, and then the next step, as Andrew alluded to, is to go and enforce it. So you may have in the construction industry on the international context, so probably more in terms of infrastructure projects, but you may have a Spanish company, a construction company that's got a good claim against an electricity authority in the Middle East somewhere. It's got a choice of law issue as to where disputes may be heard. If in fact the claim itself is based out of the construction contract itself, and not some other claim like in this for misappropriation or things like that. So assuming that you've got a claim that a contracting party can pay but won't pay, and where do you go and enforce that? Well, it may be very difficult to achieve an initial judgment in the jurisdiction of the claim itself. So for political reasons, for other reasons, and then you need to go and find where you could achieve a judgment that can be recognised internationally and enforced internationally. And that's in the context of the sorts of claims that we look at as well. I mean, some claims that are more domestic orientated and maybe of a slightly smaller size, that the money isn't as significant perhaps as considerations for electricity projects. So the enforcement question is a little bit easier, but coming into international construction contracts, it's almost the most fundamental question about whether something is financeable or not, is not the question of the validity or the rights of the claimant to receive payment, but actually the ability of the claimant or the claimant's representatives to go and obtain the appropriate redress. So it makes the consideration of the merits of a claim, which is which in all other respects is the most significant point in considering an application for funding, litigation funding to assist a claim. It almost transcends all of that, because it doesn't matter how good your claim is if you can't achieve a judgment and can't enforce that judgment. And those two steps are separate considerations. And when you come to fund it, as a funder, you say, well, how much do I have to look at the enforcement side of the claim? And what is it, if it's going to cost for the experts and the lawyers, as Andrew alluded to, if it's going to cost X to achieve on any basis a judgment, it's going to cost X plus Y to go and enforce that judgment. And that's a very relevant consideration to say, well, is it worth it in the first place to go that far to achieve a judgment that I can't achieve without spending another $5 million or so? And that $5 million has to come from the funder, because the construction company who generally you would assume is the party that's going to look for funding doesn't have it. So the funder then becomes effectively the owner of the claim, because he's the party that's most interested in achieving the settlement of the claim or the enforcement of the claim. And that poses itself interesting legal questions that Khushboo would have some points on. And it makes construction finance in the litigation, or litigation finance in the construction world, extremely difficult in areas. And I don't mean to be a doom merchant, but it is very much a not straight up and down just credit assessment when you're looking at construction finance, because of this enforceability point, particularly when you're getting into infrastructure projects and international projects. It obviously is a different thing if you've got a claim against the Department of Roads in the UK for a road built for not building the traffic lights correctly on the M25. That's a totally different issue. That's civil litigation in my world, and that's very easy to finance. But a claim in Abu Dhabi against a construction company from Spain in relation to building a project in somewhere else is very hard.
Thanks, James. I'm going to bring Khushboo in on this point on enforcement now, because it's clearly something that funders consider right from the outset. Does it matter which jurisdiction you're in, Khushboo? Are some easier than others to get enforcement in? Are there simple, straightforward claims, as James said, or is it always a nightmare if you're on an international project?
Yeah, I mean, I think James covered a lot of what I was going to say, so very helpful, James. Thank you. But enforcement prospects are definitely looked at right from the get-go. Ultimately, no one wants a paper judgment, whether you are a funder or you are a funded party. And I would think that enforceability is just as important as the merits of a claim. So having said that, I think funding arbitration claims attract an added layer of protection because of the New York Convention, as far as those jurisdictions have signed up to the New York Convention, which is obviously most of the countries in the world. But as James said, the region plays a huge, the biggest factor we take into account, the place of the litigation or the arbitration, and ultimately the place where the enforcement will take place. And these need to be considered quite closely. Many a times this could well be the same case, but more often than not, especially in construction, energy, infrastructure projects, they're really the same case. So if you have an English judgment and you're looking at enforcing in the UK, that will be a very safe judgment, safe award. But if you're looking at enforcing the judgment in, say, countries like, I don't know, Kazakhstan or India, the risk factor does change quite a bit. And there are many reasons why it changes. For example, do these countries have a reciprocal arrangement between the jurisdiction where the decision was issued and enforcement is taking place? There are some international treaties, but they're not a huge amount of guidance on it. There's time limits for enforcing. Each country ultimately has its own prescription limitation periods that needs to be taken into account. Another important consideration to bear in mind that we do see at times is whether a judgment is appealable to the higher courts, and that could be used as a means to stay the enforcement proceedings pending the appeal. Time limits for appeal can vary quite drastically depending on the jurisdictions where we're looking at. So where countries where judicial authorities and courts are proactive, those would be quite safe, quite easy. We're looking at jurisdictions like the UK, Switzerland, Singapore, Hong Kong. It wouldn't be much of an issue, but there are more riskier jurisdictions where appeals could take up to years. I had a case where our client was trying to enforce an award in India for about more than 6 or 7 years, and until now, still no progress. So, political situations also make a huge difference when you're looking at enforcement, and it gets very tricky. Just a simple analogy that came up or has come up in the COVID era is electronic signatures. That it wasn't so much of an issue in the past, but during COVID, it's really come in the limelight. So if you have an arbitral award that's electronically signed as opposed to tribunal signing with wet ink signatures, how do jurisdictions see that? Many jurisdictions in the EU have regulations that permit awards to be issued electronically. So in theory, enforcement of those awards wouldn't really be an issue. But in the Middle East, we've seen parties actually rely on the fact that the law is silent on whether e-signatures are allowed or not, and use it to resist enforcement. I think common sense generally prevails. So if not the first instance, then the higher courts in the jurisdiction wouldn't entertain such a challenge. But there's always a risk factor that's inherent in legal proceeding, which I'm sure James and Andrew would agree. So it's an extra added complication that nobody would want to entertain if it can be avoided or circumvented. And this is even more so if you're looking at enforcing litigation judgments as opposed to arbitral awards. So the long and short of it would be to pay attention to where the litigation or arbitration is taking place, where it's going to be enforced, and just undertaking duty to the extent that's possible to ensure that all procedural formalities are met.
Thanks, Khushboo. Before we go and take a look at some of the case law around funding, I just wanted to pick up on something you said, Andrew, about the different types of funding, because I've quite often always heard of it called litigation funding, but of course it's third party, it's dispute funding. You mentioned it can be used in other forms of dispute resolution, even in adjudication. And are these things you see happening regularly? Oh, you're on mute, Andrew.
the broadest sense, it can be, we can fund any type of claim where there's a route to a recovery of money at the end of it. Traditionally, funders have funded litigation and arbitration. And I guess the majority of our funding for construction claims is international arbitrations at the moment. Not a lot of English litigation, a little bit, but increasingly we're funding adjudications, and that's somewhere I'm putting a lot of effort to try and grow, because adjudications are actually, and in particular I'm talking about statutory adjudication in the UK, Canada and Australia and New Zealand. They are actually really attractive disputes for funding because of the quick turnaround. That the investment is short. It costs less the money costs less for our investors and the like. And generally speaking, the claimants have, you would have to say, the rub of the green in most adjudications, because of the nature of the dispute process. It tends to be weighted in favour of claimant. So, we think that the prospects of a successful outcome are actually slightly better in adjudications. So, I mean, well, this week, in fact, we've just approved funding for a portfolio of 5 UK adjudications. And that's generally how we want to be funding adjudications, because they're small. You group them together. It just makes the returns a little bit more attractive to our investors, and it de-risks the overall investment, because if you win one, then you can still recoup your money from the wins, even if you don't win all 5. And that also makes the pricing cheaper for the claimants. So that's an area of growth. And further, in relation to adjudications, the post-Bresco line of authority on insolvent contractor adjudications is also a potential signal for the funding and adjudication claims where insolvent parties are involved. So that's something to watch. In the international context, we can also look at funding DAB disputes. And more generally, we also are able to fund claims before they get to the formal dispute process. So we've been able to put funding into claims, and I'm sure James would say the same, claims that are still in the project context, going through a contractual claims process, where they're most likely to settle before they actually reach a resolution. So the full suite of options is technically available. Yeah.
Thanks, Andrew. So now we're going to look at some of the cases relating to funding. And so, Khushboo, come back to you. One of the most famous cases that you kind of hear crop up when you talk about funding is the Excalibur case. What happened in this case, and what are the implications for third-party funders possibly seen as engaging in champity or behaviour that is likely to interfere in the case?
So the Excalibur case, it's a classic case that very graphically illustrates the risks of funding. And the original dispute between the parties pertained to all rights in the Kurdistan region of Iraq. And the claim that was brought for was a $1.6 billion in damages. And the trial went on for 58 days. And for those of you who are not very familiar with the legal process, a 2 to 3 week trial is considered pretty painful. So a 58-day trial is bordering on torture for everyone involved. And it ultimately resulted in the High Court dismissing the claim completely. And the court actually said, the claims have been replete with defects, illogicalities, inherent impossibilities. So these are some really strong words coming from the Court of Appeal. And it ended up awarding costs on an indemnity basis against the funded party. And this means that where there's any doubt, if a sum was reasonably occurred, it's interpreted against the paying party. And this increases the amount of cost quite drastically, anywhere between 25 to 50%, as compared to where if costs were being awarded on a standard basis. So what's really relevant here is the Court of Appeal actually say that they expected funders to conduct a rigorous analysis of the law, the facts, the witnesses, and more importantly, I think the proportionality of issues along the way throughout the proceedings to make sure they're not funding a claim which is wholly unmeritorious. And while this is a high threshold, which means that must not have been a conceivable way at all that this claim could have been awarded to the claimant, I mean, if you take a step back, from the Excalibur case, I think this is one of the cases which is considered really an exception. I wouldn't say it's the norm, because a lot of our clients that are getting funded, we do see the funders undertaking a very extensive due diligence with their management and their executive committees to try and get the legal perspective on a whole array of arguments that could possibly be raised by the other side, and also to try and make an independent assessment of the claims. In particular, in the context of construction claims, there are some issues that do come up time and time again. So, for example, if there are notice provisions in the contract for variations or EOT claims, how the governing law of that contract use notice requirements and time bar issues, or where there are multiple hits of claims, double counting, say, for claims of variation, delay-related damages, disruption, acceleration, so on and so forth. The funders will be very interested to know the extent of such double counting or recovery to get a realistic assessment of the funders' parties' claims for damages. And I think ultimately what we see is funders are more interested to invest in a 1-to-10 ratio. So 10% of a realistic claim that they think that the funded party would get. But just as a concluding point, I think implications for funding frivolous suits really depends on the jurisdiction that's involved. To incentivize funders to stay in the game, most jurisdictions do adopt a very light touch approach that are not particularly intrusive to funders, whether it's through self-regulation in the UK or through holding a financial services license in Australia.
Thanks, Khushboo. James, Khushboo then mentioned that it's quite rare for cases like the Excalibur case. What is it that you funders do to make sure you're not put in those situations?
Well, what you do is you regardless of Excalibur, you behave like a responsible lender, and you take a proper evaluation of the risks that you're being asked to fund. The whole thing with and also please bear in mind that I'm a reformed lawyer, I'm a recovering lawyer. So I look at things like Excalibur, and I look at concepts like champity and maintenance, and they're guidelines for please don't behave extremely. And I think that's probably as much as anyone else in the market needs to comprehend, in the sense that if you're behaving in a way that's usurious, if you're behaving in a way that means that you are assuming a greater risk or a greater interest in the litigation as a funder than the person that actually has the claim, then you probably shouldn't be there. And as Andrew was alluding to in his discussion points, being able to assist processes and assist claimants in taking advantage / availing themselves of legal remedies and legal routes to obtaining redress is an entirely proper activity, and aligning your considerations of as a funder, aligning your considerations of the worthiness of an application for finance along the lines of what is it that you are assisting the claimant in achieving is the best way of evaluating whether there is any problem in the lending itself. I know this sounds slightly vague, but what it means is that what it's getting down to is that you shouldn't use funding to obtain an interest that is greater than or creates conflicts with the interest of the person that has the claim itself. That you cannot become the claimant ever by the act of lending money to that claimant. And there's been case laws. I mean, this goes back hundreds of years, but it's been ameliorated in jurisdictions like Australia and to a lesser extent the UK about what is proper behaviour and improper behaviour in the terms of providing liquidity to a person that has a claim. So I think you need to take it as read that companies that are regulated in an ideal world, or companies that are engaged in this behaviour, the concept of litigation finance, it's not in their interests to behave in a predatory way, because it creates an unenforceable bargain, and the only person that loses out of that is the financier, and they lose their reputation and they lose their money, and so it just doesn't make any sense to. It's important to understand what happened in Excalibur and make sure that you don't put yourself in that situation. And as Khushboo said, Excalibur is a pretty extreme version of a funding arrangement, and it didn't even. So if you ever look at take the time to read the facts of the case, it doesn't smell right in the first place. I mean, it just is not. It's just not the whole thing doesn't work and never worked. And it does show you what you need to avoid. But the basic points of litigation funding is to assist a claimant with their claim. It's to give them access to remedies and I hate saying the word justice, but that is what that's how some people like to close it. But giving a claimant the ability to pursue their contractual rights is the only basis upon which you can lend, and you should seek to lend. And if people are asking you to do something other than that, more than likely you won't pursue the lending opportunity. And it does create it creates other issues that have to be managed by the lender. It's not a problem for the borrower, it's really a problem for the lender. So it's not in their interests to behave, as I said, in a predatory way, because the lender wants to have an element of control. It wants to have an element of safety, insofar as you can ever be safe in litigation. And it wants to have an element of certainty of outcome. And so, hence my comment earlier on about when you look at these claims, you really have to, much more than you would in domestic situations. So I'm sorry that I do keep on speaking in an international context, but that's where a lot of the really interesting cases are, because of this conflicts of law issue and because of the considerations of trying to create constructs that comply with all the law, all the applicable laws, the law of the contract, the law of the party that you're enforcing on, the law of the party that's seeking redress. You need to draw into all this a common theme of, how do you get your money back in this case?
Thanks, James. I'm going to have to stop you there because we're running out of time. And we've got a few questions from the audience. Just before we take questions from the audience, Khushboo, there's again, just like a lot of areas of construction law, there's a lot of jargon around funding. One of the things we quite often hear is the arcane cap, which limits funders' liability. How does this work? And has the case last year of Chapelgate changed the way the cap is applied?
Yeah, so I'm conscious of time, so I'll try to be as quick as possible. So funders sometimes in their agreements cover adverse cost awards against the funded party during the term of the funding agreement. So this is where funders are unfortunately unsuccessful in their cases. And the arcane cap is a rule derived from a 2005 case, which provides for a scenario where if a funded party is unsuccessful in its case, this would typically mean that it would be liable to pay costs to the winning party. A funder's liability to pay costs to the successful party is limited only to the amount that it had invested in the claim. So, for example, if the funder had provided £1 million to the funded party for the cost of the proceedings, then it would only be liable for £1 million as the adverse cost to the other party. And what the Chapelgate case did was to reaffirm that the arcane cap is actually not a hard and fast or binding rule at all. It applies. Whether it applies really depends on the discretion of the courts when making an award for costs. And it does mean for funders that they can't assume that they would always be protected by this cap and may potentially find themselves exposed to a much, much larger amount than the level of funds that they had provided. I don't think the Chapelgate case means that the arcane cap is no longer relevant. I think it can still be applied by the courts in cases which resemble arcane case on its effect. So in the arcane case in particular, the funders had only provided the expert fee. So it was a very small portion of the fees that they had forked out, which is why the court thought that it wasn't fair for them to be liable to a much greater amount in adverse costs. But what the court did take into account in Chapelgate was that the funders' return, if the litigation would have been successful, would have been 5 times its investment. And another thing that's worth bearing in mind is the Arkin case was decided in 2005, which is when the market for third-party funding wasn't as sophisticated as it is now. And so there was a real need to protect funders. Whereas now, I think the funding market has developed quite a little bit. And there's a broad array of financial products. There's, ATE, which is after the event insurance. Funding agreements are also generally tailored, so they can carve out adverse cost awards depending on the arrangement, depending on the funding. So there's a lot more protection mechanism that funders have now. So the market's really changed a little bit.
Thanks, Khushboo. Andrew, I'm going to put the first question that's come in to you. This question, it says, what are the most desired cases for funders when you're looking at construction disputes? So is there a certain amount of claim size, minimum claim size? Are you looking for longer hearings, short ones? Is there a general preference on whether the UK court, international arbitration?
I'd say there's no particular preference. Certainly we like to have a wide variety of types and sizes of cases on our books. It's just a matter of diversification, really. The one thing that you need to be aware of is the actual recoverable damages in the case need to be of a certain amount in relation to the actual budget to run the case. For example, if you've got a case that's going to cost £1 million to run, you're going to need to have a significant amount more than that to recover, so that the funder can be repaid plus the success fee, but the claimants still get the lion's share of the proceeds. So that's something that's generally the main measure that we will look at when we first assess a case. In terms of jurisdictions, international arbitration, litigation, mainly English litigation or the Commonwealth jurisdictions is where Augusta would focus, but no real preference. We tend to find there's more of a market in international arbitration because so many disputes in the UK, for example, will just settle before they get to the TCC, but generally no great preference.
Thanks, Andrew. James, next question I'm going to put to you. Do you rely on the input of construction professionals, so quantity surveyors, delay analysts, technical experts, when you're analysing the risks of a claim or dispute?
You do. You either, depending on the nature of the dispute, will decide which experts have a significant amount of sway with you. Ideally, you will sometimes you'll be asked to put together a team or assist in assembling a team, and part of that assembly and therefore finance that team. So you will always be seeking an independent view to assist you in assessing the risks that are inherent in the technical aspects of the claim itself. So yeah, technical engineering, delay analysis, and all of those things are very significant points. At the stage of actually commissioning a full-blown report, that comes as part of the sometimes part of the underwriting process. Sometimes it comes as a preliminary opinion with a confirmatory opinion to be coming at the point of funding later on. So yes, it's very important because without that sort of input, you can't evaluate the amount of money involved, and ultimately, as Andrew alluded to, if there ain't any money there ain't any loan. So you need to get the as much expert opinion as you can.
Thanks, Andrew. Final question I'm going to put back to you, and maybe I'll bring Khushboo in because I think she was the one who was talking about a difficult case in India. The question is India a particularly difficult jurisdiction to fund cases in? I suppose more broadly, are there jurisdictions that you just would want to stay away from if you can, or is it entirely on the merits of the individual case?
Yeah, I certainly wouldn't say we want to stay away from India, but I think Khushboo did allude to probably the biggest in India is that time factor. When it comes to enforcement, it can be a very prolonged process, and that means our money is out for a long time if we do have to go the full distance, and that makes it more expensive. That would probably be the key point to make. But generally, there's nothing against funding in those regions.
Did you want to weigh in at all, Khushboo?
I mean, just maybe to add, I think in recent years, the landscape, generally judicial authorities over the world are kind of changing because everyone wants to portray themselves to be clean, to be good jurisdictions for investment purposes. So it's changing slowly. And the more riskier countries, we do see a lot more investments going in there from a legal perspective. So I think the world's changing, and I think even where riskier jurisdictions are concerned, I think nobody would now consider them like a no-go. Everyone's just happy to invest everywhere these days.
Yeah, and James, did you want to?
I would agree with those points, but I would add that there are practical considerations as to whether a particular dispute is worth the effort of achieving the result. And that's not to say that, so there isn't I wouldn't say there's a blacklist as such, but you would say, is it worth going to a Chinese court to obtain a judgment against the Chinese construction company in relation to a project in Africa? Probably not. So I think it's practical. It's a practical issue about what you're trying to achieve, and the sort of legal redress you're getting. So if you have to go to China to get it, you have to go to Kazakhstan to get a local order and then work from there your redress. That's a very different discussion to going to the ICC in Paris or in London to deal with an arbitration award. So that's the thing is you need to be a bit pragmatic in the way you look at jurisdictions.
Thanks, James. Well, I think that's it. I think we're going to run a quick poll now at the end just to see how you feel about the future of construction cost. Thank you, everyone who has joined us this morning and stayed on. Apologies, we've run a little over time, but I think we had a lot to cover on this morning's session. We're just asking you what you'd like to see in the future. Of course, you can get in touch with us if there are particular topics you'd like to see, or if you'd like to be involved in a future construction cost. Our next event will be next month, and I think we will be looking at adjudication. So there's nothing much left to do other than to thank our speakers for joining us. It's been a really interesting discussion. I've definitely learned a bit more about funding, and look forward to seeing you all at the next event. Thank you very much. Oh, there we go. The results of the poll. Conflicts of interest seems to be coming up. So hopefully we'll look at that in one of our future sessions. So thank you all very much this morning, and we'll see you soon.